an opportunity to prepare a payment arrangement schedule on consent of the parties. So the tenant has to agree to it, to pay back the arrears that are owed. But it's not just as simple as that, because that payment arrangement actually has to be filed with the board, referencing the application file number. And then the board will issue consent if they agree with the terms are fair. And then you don't have to go to a rent arrears hearing. The beauty of trying to do it this way is for you guys, I mean, it's better for you guys, it's not as good for us, is you get around having to attend a hearing. This is in place of attending a hearing. So any hearing that was going to be scheduled would be canceled. And then there's a term that's provided in the consent by the board under section 78 saying if the tenant defaults on any of these agreed upon payment arrangements, the landlord can file for eviction without notice against the tenant.
Well, okay, can I ask a few questions there?
Yeah, absolutely.
So let's say a scenario, someone's tenant hasn't paid the rent. We issue the N4 as normal, and then the 2-week period passes, and then we would file for an L1 and get a date whenever and however. But in between the time where we file the N1 and the time of the hearing, we can attempt to resolve the rent arrear situation with a payment plan directly with the tenant. Does that make sense?
That's right. And it's not just any kind of payment plan, guys. It actually has to be done on their form, which is available on their website.
Okay, so you don't just scratch some stuff up on the back of a napkin.
No, it has to be signed by both parties, and it has to be their form.
Okay, so that's even better. So it's their form. Tenant fills it out, landlord fills it out. You guys agree. You both sign it, and we don't even need a paralegal at that point, right? No?
Well, actually, you could do it yourself, but yes, you could do it yourself. You can always do it yourself. You can represent yourself at any time. It's really your level of comfort with how it works.
Specifically for if someone's trying to draft the agreement, it's not mandatory.
They don't need a paralegal.
But the tenant could say, I want to have a representation too.
Absolutely. And you can always self-represent yourself. It's really just about your knowledge of the process and your level of comfort. But you don't need a legal rep to sign it.
Okay. My understanding of was for them to, my understanding of why they put that in was to streamline the process so that, you didn't have to have a hearing and then, people could resolve it, like normal humans and, move on with their lives. So then so they put the agreement in, and then they have to submit it to landlord tenant board.
You have to file it. Yep.
And then the landlord tenant board responds to you, I'm assuming by a letter saying, okay, it's approved.
It's an order. Yeah. It would be an official order.
Okay. And then the tenant has to abide by that. And then now, do you have to, I just learned about this too, this section 78 eviction. So do you have to ask for that to be in the order, or it's automatically in there?
It's on there. It's on the form.
Okay. And just for everybody listening, can you explain what the section 78 kind of order?
It basically says that if the tenant or either party, in this case it's the tenant, defaults on the terms of the agreement as they're set out, then the landlord can file for eviction without notice to the tenant.
Okay, so the way I understand that in layman's terms is, you do the agreement, you file it with landlord tenant board, they respond saying, okay, it's approved. If the tenant defaults beyond that time, you don't have to reapply for a new hearing date. You can go straight to the sheriff.
So you don't reapply for a hearing date, but you do have to fill out an application that says, hey, landlord tenant board, we had this payment agreement that you consented to, tenant defaulted, here's when they defaulted, we want termination. Then you file that, and there's no hearing necessary. They just issue the order based on your application that you filed.
Okay, some good questions on that part. When does the payment plan get arranged? Okay, we talked about that. So that would, from my understanding, Oleg, so the payment arrangement would be done between the point of filing the L1 and getting the hearing date.
That's right.
Correct? Okay, yeah. So between the L1 and the hearing date.
Yeah.
After we sign the payment form with the tenant, how do you register it with the board?
You file it in. You can fax it, or it gives you instructions. You can either fax it or mail it, or I think you can email it too. There's specific ones they allow emailing as long as there's no payment required. But it tells you right there how you can send it in.
Okay, perfect. Is there an online option? Okay, she just said that. How long will it take to receive the order back?
I wish I could tell you that. It's all going to depend on how they prioritize the matters. But I will tell you that they are looking for ways to reduce the volume of video or telephone hearings. So I'm going to wager that they have someone specifically dealing with issuing the orders on those types of matters that have a payment arrangement to push
Okay.
them through.
Would we not need to prove they aren't paying to file for an eviction? I mean, well, I would say I can't see your name there. I apologize, but I would assume if you're filing an N4 and an L1 and you guys are doing an agreement, then you guys are both understanding that there's rent arrears. So that's an easy.
You actually have to sign an affidavit with the application swearing that the information is true and accurate. And if you've provided false information, you can be in big trouble. So there is an affidavit that you're swearing that says, I swear that this information is true, they did default. It's part of the application.
Oh, okay, great. The name, is there a name yet they've given the form, like an N something?
No, it's not an N form because those N forms always end up in termination. It's just called payment agreement.
Okay, so Vineet is probably on their website, or hopefully is now. You can probably download it and fool around with it and check it out. Okay, good.
Yep.
So then if they comply with the payment plan, then everything's great and you move on with your life. If they
Everything's great.
don't, then there's a Section 78 thing you can apply to get the eviction. Landlord tenant board will issue the order, and
Yep.
then you can deal with the sheriff. How long that's going to take, who knows?
Yeah, I wanted to just make sure that everybody understands too that some changes to the Bill 184 give the board discretionary power to decide on whether or not they're going to delay or deny eviction at this time based on the rent arrears that happened during COVID. We all know that. But if it will help you, even if you make attempts to have in writing, hey tenant, I'm willing to work this out. We're waiting for a hearing. The board will be asking for information as to whether or not you tried to resolve it by way of payment arrangements.
Okay, good. So it's
It's
probably in your
written
best.
right in there.
It's probably in your best interest for you to try that,
That's
rather
right.
than sitting on your hands and waiting for a hearing.
Yeah.
Yeah, I think that's a positive thing.
Oh yeah, it's great. Yeah, it's really good, and it's easy to do. I mean, if your tenant doesn't respond, c'est la vie. You've got a record of you trying to reach out, and if they do respond, then potentially you're looking at mitigating your losses and getting a resolution sooner than waiting for a hearing.
Okay, makes sense.
Yeah.
Okay, so does everybody understand that change in process then? Any more questions on that? Put it through the chat, unmute yourself. No? Okay, well, let's move on then. We can come
Okay,
back
let's
to it if
move
there's
on.
any questions.
Let's talk about the, everybody is asking me this lately, and I'm not sure if it's a result of, mortgage or financial issues during COVID, but a lot of landlords are asking me how they can go about the process of moving into a unit for personal use. Because they're either selling their primary residence or, they've decided they don't want to do this for now, or they want to use it as a tool to get a tenant out. And my first advice is never to try to use it as a tool to get a tenant to vacate the property, because with the new Bill 184, there are some specific requirements in order to stop that from happening, to protect the tenant's rights in this case. First and foremost, you have to file an affidavit swearing that you served this notice in good faith. And everybody knows that if you've sworn something on an affidavit and it's not true, you can get into a lot of trouble. You have to pay the tenant, regardless of the situation, 1 month's compensation. And sometimes when you're in a situation where they owe you 5 or 6 months, it's a hard pill to swallow that you have to pay them 1 month's compensation. Thirdly, the fines for parties who have served this notice in what they deem bad faith, meaning you're not really going to be using the unit for 1 year and they find evidence that, or evidence is brought forth that you served it in bad faith, they have increased the fine limit from $25,000 to $50,000. So there's a lot of risk of liability there.
Okay, so my first thought is like, I actually just did one of these orders because my mom wants to move into one of my units that's close to my house, so she can kind of be close to family and kids.
Yeah.
So legitimate order, but you know, let's say she moves out in 6 months. What happens then?
So the tenant has a year to file an application against you. If they found out that your mom moved out and you were re-renting it because they found it on the market, or the neighbor told them, or they drove by and could see someone moving out, they have a year to file an application. In addition to the fine that the board can implement against you, the tenant can also be awarded up to 1 year's worth of rent.
Interesting. So, but how do they go after? They file something with the landlord and tenant board?
Yeah, it's an application about their rights.
Got it.
Yeah.
Okay.
And then, you know, you'll have to defend yourself. Sometimes it really does happen that life circumstances change, and for all, you know, your intention was to live in the unit for a year, but after 6 months, something happened, and you would have to explain that situation to defend yourself at the board, and they will make a decision as to whether or not your notice was actually served in good faith at that time, and the reason why you didn't reside in the unit for a year was based on reasonable circumstances. You have an opportunity to defend yourself. But what I'm trying to get at is if it's not justified, you are exposing yourself significantly.
Yeah, definitely. Yeah. So beyond 12 months, then there's no recourse.
That's right.
For the tenant.
It's past the limitation period.
Okay, I saw that was a change because in the past they had longer to get recourse. Am I correct?
No, it was always 1 year for them to file after they vacated. What changed about filing after the tenant vacated was, in the past, landlords could only file applications against tenants if they still had possession of the unit. Now landlords also have up to a year to file applications against the tenant for damage to property, non-payment of utilities, rent arrears, and that's significantly in the landlord's favor, because to pursue action through the landlord tenant board is much more cost effective than having to commence a new action in small claims court.
Yeah, I remember that now. Thanks for reminding me. I think that's amazing because all the tenants were taking advantage of that. The landlord tenant board is saying, "Oops, they moved out," and small claims is like, you know, screw you, go see the LTB.
Yeah, there was a really big gap between what the rules of the small claims court were and the judge's interpretations, because they felt because they were landlord tenant board matters, they should have been dealt with under the jurisdiction of the board. Well, they fixed that now because you have a year, and if you don't, you're out of luck.
Yeah, I think that's more than fair. Okay,
I agree. That's a really good plus for landlords.
Will this process always require both N4 and L1, or can one skip the 2 steps? So I think you're talking about no, you can't do that. So Wesley,
absolutely not. It's a requirement to follow the service of the N4, the filing of the L1 application. They need proof that you're taking the steps per the act, and then they'll consider consenting to payment arrangements. It's the process that has to be followed in that order.
Okay. So to clarify, has the ability to evict already been reinstated? So is the eviction ban canceled, I think is what you're asking, or is there a future effective date for this?
Say again?
I think this gentleman is asking, has the eviction ban been lifted?
Yes, it has. Absolutely. Yeah.
Okay.
I've already received eviction dates for matters for evictions that were scheduled in March. I actually was speaking with one of the sheriffs from one of the regions here, and he was expecting a big floodgate of evictions, but it hasn't happened yet. And truly, it's because the board is holding things up. They are not issuing the orders. There's a backlog. I mean, it's significant, and I'd like to maybe take this moment for everybody to really consider, if they're being affected by the delays at the board, call the ombudsman, file your complaint,
Yes.
tell them what's happened, and the more voices they hear, the bigger the accountability is going to be on the process at the board.
Yeah, so we spoke about this, man, I don't know if it was the end of last year they were doing this or beginning of this year. Anyway, I called the ombudsman myself, and to tell them, my version, and someone actually called me back, and they said, "Oh, why do you think there's delays?" And he just asked me for my opinion on a whole bunch of different things, and they took it and they said, "Thank you, this helps us kind of try and make the process better." So to Kelly's point, if you're experiencing delays or have experienced delays in the past, I would definitely call the ombudsman, and I'll try and find the info if I can and put it in the email.
It's really, yeah, just Google Ombudsman Paul Dubé and it will bring up their website. There's a the complaint form that you can file online, actually.
Yes. Yeah, please
Yeah,
do
and
it.
more landlords need to do it.
If it's one thing to complain, but if you have an outlet to actually make some progress, I think it's your responsibility as a landlord to go ahead.
And now is the time to do it, because they're in an active investigation against the access to justice because of the delays at the board. They are in an active investigation. Now everybody has to speak up.
Yeah.
Yeah.
Okay. Question here from Julia. Tenants rent the whole house that includes a bachelor with a separate entrance. Now their son moved out, but the landlords want to move in there just in the bachelor. Can the landlord sublease from their own tenants? Ooh. Did you catch that
Can the
question?
landlord sublease from their own tenants?
Yeah.
That's messy.
Yeah, I think so.
I suppose on paper it could be done, but it certainly would not be advisable.
Yeah, I think so. Oh,
And
yeah.
then you run into it could actually, in some circumstances, it might work, because if you're moving back in and you're renting to your tenant like only one room, you wouldn't technically be subleasing from your tenant. You would be a landlord who's moving into the unit if they consent to this. And actually, if you live in the same unit as your tenant and you share a kitchen and the bathroom, it is not covered under the Residential Tenancies Act. So if you want them out, you're trespassing, no notice period, you got to go.
Wow, very good.
Yeah.
I'm gonna remember that one.
Well,
Okay.
you want to share with your tenant? You want to move in and share a kitchen and a bathroom with your tenant?
Well, I mean, anyway, let's not go there. I'm not gonna go off on a tangent.
Okay.
From Oleg. Okay, this is a great one because we've had this issue a bunch of times. If I want to sell, what do I need to do with tenants given the ban on evictions? Can they refuse to leave even if I sell some to somebody who wants to move in?
Okay, this is actually a very hot topic. So there is no ban on evictions right now. It has been lifted, so that answers your first question. They are moving forward. While it is slow, they are moving forward. So if you're selling the property and someone requires it for personal use, then the N12 notice has to be served and the proper process has to be followed. Filing the N12 with the application to the board, paying the tenant compensation prior to the termination date on the notice, and filing that affidavit that the purchaser does require it for personal use with your application. All you can do is wait for a hearing date to get the order from the board. So you want to make sure you're building in sort of an extended closing date, or the option to extend the closing date based on the availability of the hearing.
So Oleg, I've had 3 experiences with this so far, and one of them went completely sideways that Kelly had to deal with, and the other 2 were fine. The one tenant just said, "Okay, I'll just move out for closing," so that was easy. And the other one sort of put up a little bit of a fight, but the landlord got the affidavit from the buyer. I represented the seller. The buyer gave us an affidavit. They filed it, and as soon as it was filed, the tenant's like, "Okay, I'm leaving on my own accord." They didn't need to get a sheriff or anything. So the affidavit is key. If I'm listing your house or selling your house for you, I'm saying to the buyer, you need to give me an affidavit. Even if you say the seller is going to get vacant possession, or the seller must provide vacant possession, it doesn't matter. I still need an affidavit from the buyer for sure.
I actually will not serve the N12 notice for my clients unless I have the affidavit first, because I am not going to expose them to the risk of liability for serving the notice in bad faith.
Yep, that's a good one.
Yeah. The other thing is if you don't want to pay the tenant compensation and you're in the position of offering them another unit that they agree to take, then you don't need to pay the compensation and they can just move into another unit. There are some circumstances like that as well. That would be the only way that you wouldn't have to pay the tenant compensation.
I think that, just my opinion, but I think that's something they have to change in the future too, because I can understand paying them a month's compensation if you want to move your mom in or move yourself in. But if another buyer is buying the property, like, I don't see that as something that should be compensated.
It's really to control the market rent and make housing available to other people. That's truly what it is, because you can't increase the rent if you have an existing tenant in there unless you do it by the guidelines. And as soon as someone moves out, if it's an investor buying the property, the way they look at it is they can put it at, they can put the rent at whatever amount they want, but it makes access to reasonable housing costs difficult for tenants. And you guys know I'm a landlord rep. I don't represent tenants. So it's truly, that's the way they look at it, just so that, there's some context to why it's set up that way.
If I had Mrs. Kathleen Wynn or Doug, or both of them, Doug Ford here, I would say, hey, if you want to help control rents and actually help your tenants and help the landlords, why don't you get rid of the HST on new construction? So
then they, what they did though, they gave you guys with the new construction units that the rent is not bound by the rental increase guideline. So, if it's a new construction after 1998 and it's the first time it's being used as a rental unit, that rent amount is not regulated by the guideline. You can increase it to whatever you want on an annual basis.
Yeah, my understanding was not 2008, 2018.
That's right. Did I say 8? I meant 18.
Yeah. Okay.
Yeah.
Good.
November 2018.
Yeah, fair. If I build something new and I build affordable housing, and it's built after 2018, I'm not subject to rent control. But my argument is, like, I just built stuff like that. I built 2 semis, each with their own accessory suite in the basement, so 4 units. And the bill for HST, get ready to drop your jaw, for just those 2 semis and the basement suites is $130,000. That's insane.
That's where they're getting their money from.
That's insane. And then it's like, oh, we want the rents to go down, or we want rents to be fair. Well, how can you make rent fair and I got to pay you 130 grand? It doesn't make any sense, right? So anyway, that's just
a lot of it doesn't make sense. And I think it's really that they don't put all the pieces together, because it sometimes it's not logical.
Okay.
I agree. Yeah.
Here's a good one. If we want to move into our property and the tenant is still within the 12-month lease period, how does that work?
You can sell your property at any time. even if there's a fixed term in place. You're entitled to sell your property.
Okay, good. Okay, let's hold on some of these questions now because I think there's more content regarding the Bill 184 that we should talk about. Is that right, Kelly?
Sure, yeah. I made some notes. Just let me double check what I wanted to make sure that I shared with you guys. Oh, let's talk about utilities, because unpaid utilities is something that a lot of landlords have issues with. The great news for landlords is in the past, they were only allowed to file with the board an application that said, hey, tenant has failed to pay the utilities, and they want a termination because they've defaulted on the terms of the lease agreement. The board was able to issue an order for termination if the tenant didn't comply and make payments, but that could only be done while the tenant had possession of the unit. That also now falls under the year limitation, which is a big thing, because oftentimes landlords don't find out that utilities haven't been paid until it's transferred onto their property tax.
Yes. Yes. Yeah, that's a good one. Okay.
So that's something I wanted to make sure that everybody was aware of.
What else?
The big ones are, we really touched on a lot of the big ones with the rent arrears and
okay, so let's go to some of these questions. If I am doing a renovation of the rented house, can I increase the rent when I rent it to the same tenant after renovation?
well, the short answer is yes, but the long answer is you would have to apply for something we call AGIs. They're called above guideline increases. You would have to serve proper notice, file all the required documentation with the board for them to issue an order for you to be able to increase the rent above the guideline.
Okay.
And they cap it out at 3% per year.
Okay, but if my understanding is if I serve them with the notice that they have to leave because I want to do extensive renovation, that's like an N8 or something like that.
Oh, I'm sorry. They get to move back in even when the renovations are done at the same rent amount. So unless you've got an above guideline increase, the tenant has the right to move back in.
Mm-hmm. Got it.
At the same rent. And the only way you can increase the rent to offset the costs that you've spent on the renovations is to file for an above guideline increase.
Mm-hmm. Now, what if, I mean, like, even that one is so great. Like, I'm just finishing a renovation now that's taken 10 months. That was supposed to take 4 months. I mean, that's the way renovations go. Now, I didn't kick anybody out. It was already vacant. But if I had kicked someone out, where are they going for 10 months? They're renting another place or buying another house or moving in with their parents. Like, if they're not knocking on my door to come back, like, I'm just renting it to whoever I want after. No?
It has been done that way, but if the tenant comes back, you do have some exposure to risk of litigation there. But most tenants move on because they've settled somewhere else. It takes too long, blah, 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 all those reasons. But there are those ones that want to hang on and have a new place at the same rent. So they do like a short-term rental somewhere else and keep renewing it until you're done. There are tenants like that.
Yeah, that's where I was hoping there would be some changes, like okay, if it's the renovation's gonna, or you don't reach out to the tenant or the landlord after 12 months, then that's it, you're finished. You can't go back to them after anything. But
that would be nice. That would be fair and reasonable. Sure.
Yeah.
But they haven't made that change yet.
Does go ahead.
I had one more thing I wanted to talk about, and that's changed from the Bill 184, and it's with respect to rent increases. Since we just talked about rent increases, it's not so much about above guideline rent increases. It's about what in the past would be deemed illegal rent increases. So let's say the parties, the landlord didn't serve the N1, the landlord didn't give the 90 days notice of the rent increase, and it was more than the guideline increase for that year. In the past, the tenant didn't have to pay it. And if they got called to the board because of non-payment of rent, the landlord could get into a lot of trouble for increasing the rent above the guideline and what is called illegal rent increase. Now, if the tenant pays it for a 12-month period, it's deemed valid and not illegal.
Yeah, I think that's fair. That's more than fair.
Yeah. So that's a plus in sort of the landlord's toolbox there too.
Okay. Does the inclusion of utility in eviction now mean that if the tenant pays rent but fails to pay utilities, one can issue an N4 to initiate eviction?
So it's never the N4 for utilities. That notice is always only for rent arrears. It would actually be the N5 notice.
Got it. Okay, thank you. So from Leah, what should I do? Love that. My tenant just moved in our property and is putting all their commercial tools in their backyard, and that's not part of the lease. What can I do about it?
You can serve them with the N5 notice, and you have to be very specific as to why you're serving that notice. It gives them a 7-day remedy period. Again, you're going to want to go back and check after the 7-day remedy period to see if they've complied with everything that was set out on the N5 notice and removing all of these the commercial equipment or vehicles or whatever it is. And if not, then you file with the board and you're seeking termination and potentially damages if they're parking trucks and equipment on grass and things like that.
Yeah, okay, good. I just had one of these. One of my tenants decided to put in a pool, like an above ground pool. And,
Yeah,
the city came by and said, hey, if we have to issue a fine, it's coming to the owner, not to the tenant. So we took care of that. The property manager was able to resolve that, and they dismantled it. So thank God.
Yeah, that actually came up a lot during the height of the shutdown because people weren't able to go to the beaches and it was so extremely hot. I would say, 5 out of 10 calls I got were about people putting inflatable pools or above ground pools in their property. There's some, big risks for the landlord for personal injury, number 1, number 2, affecting your insurance policy, number 3, bylaws. All those things have to be looked at when you're either consenting to someone to do that or if they've done it without your consent.
Okay, good.
Yeah.
So from Prav again, following up on my renovation question, if the term is about to end, I'm assuming you mean the lease term is about to end and the tenant wants to continue, can I end the tenancy at the end of the term and then do the renovation?
No, you cannot end the tenancy at the end of the term. The only way the tenancy can end at the end of the term is if the tenant gives notice or if there's been an order issued by the board terminating the tenancy. The tenant can stay in there as long as they want, as long as, even if it's only 1 year or a 2-year fixed term or 3. At the end, it automatically transfers to month and only ends by notice of the tenant or an order by the board.
Mm-hmm. Got it. Yeah, I mean, we're always pretty vocal with our tenants when there is something going on. And I maybe it's just me, but I feel like 8 out of 10 times we're able to resolve little things like that, without end up in landlord tenant board. So, I mean,
I would
I'd always.
agree. And yeah, sorry, Paul, I would agree. And I always suggest, first attempt is trying to resolve it. Legal attempt is like your last resort because there's no turning back, right? And oftentimes there's a ripple effect where if it's an issue about a pool or damage or something like that, then all of a sudden they stop paying rent. So it's always best to try to resolve it first before you proceed legally.
Yeah, and I think if you're firm and get to the point and kind of respect them also, I mean, I've been pretty successful that way. So I'd advise
that's good.
everyone, just try yourself first. So and don't make it a stressful situation if you don't have to. Okay. Any other questions for Kelly? Unmute yourself or pop it in the chat. Okay. Was there anything else on Bill 184 that we wanted to cover?
I think we've covered all the really the top highlights. Yeah, I mean, are we all landlords present here, or is there some tenants here too?
I don't know if anyone wants to admit that.
Okay.
I think it's all landlords.
I think it's just really important that if you haven't had a look at the bill, it's only Schedule 4 that relates to the changes to the Residential Tenancies Act. And if you just have a look at it and have any questions, you know, it's pretty easy to clarify what's set out there if you're reaching out to someone who should know all about it. And it's just really important for landlords to know what new tools are available to them, how they can exercise their rights, and that will only assist in mitigating any potential losses and perhaps, you know, a further breakdown of the tenant-landlord relationship.
So I mean, I'm no expert, but from what I could see, most of the changes look pretty positive. Or I would let me rephrase and say, it looked like it was making the Tenancy Act a little bit more fair and even for landlords in a sense, because we all know it's pretty biased going the other way. So although they changed some of the penalties and stuff like that, I mean, you shouldn't be doing that stuff anyway. So I think it was positive.
I agree. I really think that there's a lot of cool stuff in there that I can help my clients better with as well. The only tricky challenge is making sure that you're meeting all of the requirements, because as much as the bill sets out what the changes are, you have to understand how to find, you know, the related requirements in the Residential Tenancies Act, so that you're not filing some kind of application based on a new change and getting to your hearing and it being dismissed because you did not comply with all these tricky little requirements that they've put in place.
Got it.
For the process. So they're giving it to you, but they're making you work for it.
One thing I noticed was, I guess there's a bunch of articles on Google that I saw when I was researching it, is a lot of the tenant advocacy groups were sort of crying as usual that you know, this would cause a flood of evictions or something, because you know, some tenants, or they feel tenants would be taken advantage of if they had to sign an agreement with the landlord for repayment of arrears. And you know, they expected that the tenants should have some kind of, you know, representation at that point. I mean, I thought that was kind of ridiculous, but what do
It
I
is
know?
ridiculous because they have access to free duty counsel. They also have access to a lot of free legal resources that landlords do not have access to. And they also have access to many different processes which can still deny an eviction.
Yeah, that's what
Meaning, even if it's stamped and the ink is dry and you filed it with the sheriff, they can still file a motion to stay the eviction based on ridiculous reasons that would have to be heard in a hearing situation. And then either the stay is lifted or the eviction is denied based on whatever reasons they've given. But in my experience, it's usually unsubstantiated reasons, and it's a delay tactic. They still have the ability to delay and deny, and have been given so many opportunities to work out some kind of payment arrangement.
Mm-hmm. Got it. Okay, a few more questions come in. Let's do these questions, and then maybe we'll wrap it up if there's no more. So with Bill 184, as of what date does landlord go through the board for damages instead of small claims court?
So all of the forms are available now on the Landlord Tenant Board website. They've updated a whole bunch of forms. They've taken away some that don't apply anymore because they used to have one on there during COVID for urgent hearings that were being held during the shutdown for serious impairment of safety or illegal activity. So they've updated all their forms in accordance to the changes, and they're available to utilize now.
Okay. From Leroy, purchasing a house, can you request that the seller end the tenancy before or after 12 months? For example, wanting one tenant to leave in a duplex. Leroy, if you can clarify a little bit, if you don't mind, but I'm assuming you're saying, if you're purchasing, can you request one of the units in the duplex to be vacant, regardless if the lease is within 12 months or beyond 12 months?
Perfect. You got it bang on.
Okay, good.
Hi, Leroy. So basically, even if it's in the first year term, is that what I'm understanding? You can still request that it's vacant for the reason that the purchaser requires it for personal use.
Yeah. Yeah.
And I suppose
Go
I
ahead.
guess if the seller would have to worry about compensating the tenant, that would, maybe it shows up in the purchase of sale or whatever, but to end the tenancy, does that still apply? So, we have to give them 1 month's rent.
Yep, you still have to do the same process.
Okay.
The seller would.
The
Yeah.
seller would.
Yeah. Yeah.
And you would have to provide an affidavit to do it properly, unless the tenant agrees to leave on their own.
That's right. Yeah. And sometimes they do for cash for keys, right?
Yeah. Yes.
Although they're getting a little bit more demanding on how much they're asking for now. I heard one ridiculous, like 12 grand or something. That was last week. I was like, what? The rent is 1,100 a month. I don't think so.
Right. Okay, good question, Leroy. Was thinking of officially giving a rent increase for the sake of time stamping the 2% increase allowed this year. But because it has been a difficult year, modifying the effective date beyond the 90-day notice well into 2021. I'm not sure what you're asking.
I'm not either, but I can tell you what the process is. You're allowed by rights to increase the rent every 12-month period by giving the tenant 90 days notice, and it has to be given at the increase date has to start at the beginning of the rent cycle. So it can't be like it starts on the 6th of the month if the rent cycle is the 1st.
Yep.
Hi, guys.
Okay.
Can I clarify that?
Yeah, go ahead.
All right, thanks. Great presentation, by the way. Thank you for everything. I was just thinking, like because we get to officially it was 2% this year, like woohoo, right, for the rent increase, right? Normally it's not that high, and I suspect next year it probably won't be this high based on inflation and all that. And in other words, that ability to raise it that amount probably won't exist next year, I suspect. Based on that, I guess I was wondering if it would make sense for me to give them an official rent increase now, so that I've sort of locked that in, but in acknowledgement of the fact that, it's been a difficult year financially for a lot of people, probably several of my tenants. Say, hey, for the time being, this is actually like I'm not enforcing this.
I see.
Yeah, so that I can do it at a later date when, say, the economy's picking up and
So you want to market the time now, but not enforce the increase, so that next year at this time, if you want to do it, you can do it, in August or September.
Yeah, because I think if I'm correct, like if you don't do it in the previous year, you can't do things retroactively, right?
No.
No, you cannot.
So I was just wondering if that seems like a viable option, or does that make sense? Or I don't know, like just a thought. Like if things are all good next year, well, probably won't be, but things pick up a bit. I'd have that option of like implementing that 2%, across my properties.
The risks that I would see there for you is if you've implemented a rent increase and you haven't enforced it, and the tenant isn't paying what is the proper amount of rent, and the relationship breaks down somehow, how much are you going to be setting out on the end for? And when you're at a hearing, that is definitely going to come into play. And I would wager that they're going to say you should have been collecting the correct amount of rent, especially if they've been paying a certain amount and you haven't tried to pursue recovery of any kind of rent arrears. You could have essentially established that the rent amount is not increased, and then you'll be not ahead.
Yeah.
Yeah.
I would say either do it or don't do it.
Yeah. Okay. Yeah.
Yeah.
Sorry,
Right.
I can't see your name. Your name doesn't come up properly here. Do you mind sharing?
Oh
your
yeah,
name?
sorry, it's Andrew. Yeah, it's I think that's because it's my company. It's my company
That's okay.
iPad. Yeah, but
Okay.
thank you
Well,
very
thanks
much,
for the
guys.
question.
I
Yeah, no
appreciate it.
problem. No problem.
Let me see here. What are some examples of situations that could deny an eviction? Oh my God.
That's a great question. That's a great question. To deny an eviction is pretty significant. The reasons would have to be pretty significant, meaning the landlord has done something egregious. There's significant maintenance issues that have not been repaired. There's some kind of bad faith on the landlord. They've infringed on the tenant's rights. Those are reasons to deny an eviction. But the burden is on the tenant to prove that. There are many reasons, on the other hand, to delay an eviction that hit all sorts of topics on the spectrum: human rights, illness, disabilities. So many situations could delay an eviction rather than deny it. But at the same time, it's not something that is a for sure that you'll be denied or delayed. It's something that you would have an opportunity to defend your position on and make sure that your rights aren't being infringed upon, and make your argument to the board why they should not delay or deny.
Okay. So thanks for that, Kelly. So we're coming up to the end here. I just want everyone to know that Kelly's available if you need help, with any landlord tenant board issues. We'll share her email address and contact information when I send this replay out by email.
Yeah, and I put together a new website too, guys, so check that out as well.
Well, you know what? Tell me what it is. I'll put it through the chat just in case.
Sure.
And
It's
then
www.khparalegal.com.
How do you spell it? Okay, here we go. Okay, that's through the chat. And then your email is...
Oh, it's paralegal.
Oh my God, I'm terrible. www.khparalegal.com. Okay. And then your email address?
It's kelly@khparalegal.com.
Kelly@KH.
Or a lot of you guys have my older one, which is khparalegal@gmail.com, and that one's still active too.
Okay. So there's a website and email address. If you want to get a replay of this and you're not on my email newsletter, I'll put a link in here so you can jump on, okay? I'll just put that. Okay, so if you want, you could just go to my website, and any link that is offers something, you can put your name and email, and you'll automatically be on my newsletter and kind of get the replay if you want it. What else, Kelly? Do you want to share anything else before we end it?
Just so you guys know, that there's many good things that happen with this Bill 184. Just familiarize yourself with it and make sure that you have the tools available to protect yourself and to advance, applications or some kind of action to mitigate any losses. And I think that's it. Good luck, everybody, and you know how to reach me if you need me.
Okay, cool. So, I mean, I think most of you know who I am and what I do, but really quickly, I mean, obviously I work with a lot of investors and landlords like yourselves, and, we're always helping people buy and sell properties, acquire and sell and make your money, all that kind of stuff. And we do a lot of coaching and advising and, create a lot of content like this. So if you like it, jump on my newsletter and you can get a lot of great content just like this. Okay, guys, talk to you soon. I'm going to end the recording, and we'll be in touch again.
Thank you, everyone. Take care.